All right, welcome back to our RICO Law Digital Justice Conference 2020. Coming up is our international panel discussion with international guests and an international audience. The panel is on a topic of online dispute resolution and is going to be hosted by my fellow RICO Law colleague, Julian. He's a PhD student and researching on the topic of online dispute resolution. Afterwards, we will draw a final conclusion on the past 2 conference days, and some personal impressions will be presented by our team members. So stay tuned, but first of all, it's over to you, Julian, and we'll, looking forward to it.
Well, thank you, Ramona, and welcome from my side. Welcome to the speakers. Good morning to Colin Rule and Shannon Salter, because it's 8 a.m. where they are at. They are in San Jose, USA, and Vancouver, Canada. And good afternoon to Martin Fries, who is in Munich right now. And thank you all for taking the time and being a part of this discussion here, which is, so to speak, the finale of a 2-day conference on digital justice. And of course, welcome to every one of you who's watching. By now we had like 450 signups, so there are a few of you watching. I specifically encourage you to use the chat function, talk to each other, discuss, send some useful links maybe, and of course post questions to our speakers, and we will try to include as many as the time allows. On the topic we want to discuss. In this panel, we want to discuss online dispute resolution. So this term is including a broad range of instruments to solve disputes online, and so far this was or is dominated by the private sector. The best known example is the PayPal and eBay systems. In German, it's called PayPal Käuferschutz, and it has been referenced again and again throughout this conference. So it's a great way to conclude the conference and actually talking about just that. It's huge actually, because already in 2014, it's been said that these systems were handling 60 million cases each year with a growing tendencies. And all at the same time, in Germany at least, the new cases at the courts are shrinking. Already 15 years in a row now, we've heard it this morning, Kurt Brüggemann said it, Gisela Rühl, and it's 40% less of cases compared to 2005. So we want to discuss 3 main questions. The first is what to think of the rise of private ODR, and especially eBay, PayPal, etc. What role should they play also in relation to the state? Is it bad because the state loses meaning? Maybe does even the law lose meaning? Or is it good because it's a chance for more access to justice? Maybe it's something in between. Second big question, do the platforms need more rules in this regard? And then the third, anyway, can the state learn something from eBay and PayPal? So every one of the speakers will introduce herself and her background in a 10 to 15 minute talk, whereafter we will enter into an open discussion. And I will now quickly introduce everyone and then give the word to Colin, who will start. I welcome Colin Rule. He has built the eBay resolution system and led it as director from around 2000 onwards for more than 10 years. And that's why he is referred to sometimes as the godfather of ODR. Today he runs another ODR platform called Mediate.com. I also welcome Martin Fries. He's a German lecturer and researcher at the University of Munich in the law of digitization and has published a few papers on our topic. And I welcome Shannon Salter. She's the chair of the Civil Resolution Tribunal in British Columbia, Canada, which is one of the first successful online courts worldwide. So Colin, why don't you start? Maybe we can learn a little how the eBay system works and what's your take on the topic. The stage is yours.
Absolutely. Thank you so much, Julian, for that lovely introduction. Good morning, everyone. Delighted to be here with all of you. I will begin by saying I hold my co-panelists in the highest esteem, particularly Shannon, who I've collaborated with for many years. But the structure of this panel seems to be sort of talking about public versus private. So forgive me if I play a little bit of devil's advocate today, just to keep things interesting. Let me click the magic button here and see if I can share my presentation slides. So hopefully... if someone can confirm that you're looking at a slide that says Reimagining Justice.
Yes.
Okay, good. Excellent. So let me just talk a little bit about the transformations that I see happening in the world today around the justice system, particularly with the expansion of technology. If you look at other industries like medicine or finance or entertainment, all of these industries have been essentially completely reinvented by technology. If you were to take a practitioner out of those fields from 20 or 30 years ago and drop them into those fields today, it would look entirely new to them. But that has not yet happened to the justice system. But my argument is it is inevitable that it is about to happen to the justice system. Technology is changing the very way that we interact with each other, especially looking around in our post-COVID world. Essentially, technology has become the primary way that we interact with each other around the world. And what that's doing is it's redesigning our society. And obviously, the justice system is an essential component of civil society. So if the internet is reinventing the way that we interact, doesn't it also make sense that the internet would lead to a reinvention of the way that we resolve our disputes? So I come from the online dispute resolution field. I'm not a lawyer. My background actually is in public policy. And so I've spent my whole career resolving disputes. And the online dispute resolution field is about exploring the use of how technology can help people not only resolve their disputes, but prevent and manage those disputes as well. So we take a very broad look at a very sort of a blank piece of paper look at what is the optimal way that we can utilize technology to provide people fast and fair resolutions. And yes, deliver justice. Now, the internet, any of us can pull out our phones right now, and with a couple swipes of our finger, we can buy an item from anyone, anywhere in the world. The internet does not really care about the distinction between Canada or the United States, or Germany versus France, or indeed North America versus Asia. All of us can interact on the internet very seamlessly. But unfortunately, the justice system, the way it was created, is very dependent on geography and jurisdiction. So imagine if I'm a buyer in Germany and I buy an item from a seller in Australia off of a marketplace which is based in the United States, and that item is shipped out of China. Well, okay, the item's only worth 100 euros. What do I do if I have a problem with that item? How would I get resolution through the justice system? Would I file a dispute in the German courts? Well, why would the seller, who's based in Australia, care about a decision from the German courts? Would I file a dispute in Australia? Well, the value of the item is so low, it's going to cost me more to speak to an attorney in Australia than it will to just say, forget it, I'm just going to give up. So if e-commerce, which is growing so rapidly, and now we have more than 1 billion cross-border disputes every year, if e-commerce is going to essentially take over most of our transactions, the justice system, the way it's currently designed, based on geography and jurisdiction, is essentially irrelevant. And this is what we realized at eBay and PayPal. We realized we had to build a new justice system because we had more than 250 million users all over the world in 16 different languages, and they each lived in different jurisdictions. So how could we build a fast and fair resolution system? We also discovered at eBay and PayPal, people would rather lose their dispute quickly than win their dispute and have it take a long period of time. And a long period of time on eBay was 12 days. So people expected their resolution in a matter of days, and they wanted these systems to be available 24/7. So there is no way that the judicial system can deliver a resolution for a complex cross-jurisdictional dispute in less than 12 days, much less in a few months. So essentially what we did at eBay and PayPal was we built something called the Resolution Center. And thank you for sharing some of the statistics. We did resolve more than 60 million disputes per year. Now that was 10 years ago. So I bet that number has more than doubled since then. And eBay was the largest e-commerce marketplace in the world world from 2000 to 2010. But now we have Amazon and now we have Alibaba, which are much larger. And I guarantee they're doing even more disputes. And we got to the point using the software at the Resolution Center where 50% of those disputes could be resolved amicably between the buyer and seller, meaning they could resolve the issue themselves through mutual communication. And 90% of those cases were resolved automatically in software, meaning it was just the software program that we wrote working with the two parties, the buyer and seller, to reach an agreement. And an eBay employee did not have to touch the case. Now, that still meant we had 6 million disputes per year we had to resolve, which is a lot of disputes because we only had 25,000 employees. But it also meant that we got much faster, more efficient resolutions. Now, all of those outcomes were appealable in a court. They were not binding in the sense that if any of the parties wanted to go to a court and file a case, they could. But what we found was 99.999% of those resolutions did not proceed to a court because the cases were so low value and because the parties perceived the eBay resolution process as being fair. And eBay had the ability to enforce outcomes. So if we decided that a buyer was entitled to a refund, we could take the money from the seller via PayPal and give it to the buyer. So they didn't have to go to court to get their outcomes enforced. So what we've seen is this same approach, the Resolution Center, we spun this out into a separate company called Modria in 2011. And we started looking at other areas of society that could also benefit from resolution centers. And we found many of them, not only e-commerce companies like eBay, but also Uber and Lyft. They have rider passenger disputes, or Airbnb, which has host guest disputes. You can imagine any collaborative economy company, sharing economy company, they have many disputes to be resolved. And all of them now have created similar resolution centers. But also offline consumer disputes. Even in British Columbia, we worked with Consumer Protection British Columbia to provide resolutions in disputes with nail salons or disputes with your cable provider or your cell phone provider. So then we started to transition into higher dollar value disputes. So we use resolution centers to resolve insurance disputes or product liability cases, or even public disputes like tax disputes. That became a huge area for us. So we started to see that this approach that we built at eBay and PayPal was relevant in many other case volumes. Now, I never wanted to sell to the courts. That was never my aspiration in starting Modria or working at eBay. I wanted to buy bulletin boards outside of the courts that said in big letters, don't go in there. Come to Modria.com. We will resolve your dispute faster, better, more efficiently. But eventually, Modria was acquired by a company called Tyler Technologies, which builds all of the technology for most of the courts in the United States. And then they started to integrate online dispute resolution into the courts. So we can talk about that and essentially how the courts are reshaping online dispute resolution. I would say the best example of the use of ODR in a court anywhere in the world is the Civil Resolution Tribunal, which Shannon runs in British Columbia. That's the high watermark for what can be achieved. But there are many other courts that are deploying ODR in ways that give me pause, which we can discuss. So this is my last slide. If you look around the world, online dispute resolution in the private sector continues to accelerate. We see APEC, which is the treaty organization, the international organization of all of the countries ringing the Pacific Ocean. They've passed a design for small and medium-sized business online dispute resolution with all of the rules. So you have an expedited process for resolving those business disputes so you don't have to go to court. ICANN, which administers the Global Domain Name Network, they have a program that's run for decades now called the UDRP, the Uniform Domain Name Dispute Resolution Protocol. And it's resolving disputes. It's resolved tens of thousands of disputes, again, never having to go to a court. And it has automatic enforcement because they control the database of domain names. The European Union passed a regulation which requires online dispute resolution to be available to all consumers in cross-border e-commerce transactions, and those are private providers. And then UNCITRAL had a 7-year program to explore how we could create a better infrastructure for cross-border dispute resolution, particularly for these low-value, high-volume consumer transactions. So again, ODR's sweet spot right now in the private sector are these low dollar value transactions, most of which won't make it to a court. The courts obviously specialize in higher dollar value cases, but we see that ODR is working its way up the value chain. And as ODR becomes more sophisticated and more flexible, I have no doubt that it will continue to be applied to the types of higher dollar value cases that the courts currently work on. The other thing that I will note, if you look at websites like Jur or Claros, they are starting to build a new justice system which is based on math as opposed to the coercive power of the state. It works very much like Bitcoin and virtual currencies and smart contracts. And that is a truly revolutionary a vision for the future of justice, one that has no lawyers, it has no laws, it has no courts, it has no jails. Essentially, you back all of the resolutions in the world with math, and you lock all of the transactions into an environment where enforcement is built in. So yes, the question is not where we are today, it's also where we are going. And if you look at the trends, it's very much the digitization of justice and the expansion of ODR as the primary means of redress for people interacting online. So I'll stop there and I'll hand it over to my co-panelists, and I very much look forward to the rest of the conversation. Thank you very much.
Great, Colin. That was a fantastic intro. Just two more questions to detail a few of the points you made. I'm interested in the 90% you were able, or the eBay and PayPal systems is able to solve the conflict or the cases without human interaction. So what does that mean? If it's amicably solved, I can imagine, okay, the software helps just sending a message to the other part, and then they get along. But in different situations, what can the software do?
Sure, well, that's an excellent question, Julian. In ODR theory, we have something called the fourth party. And fourth party is the way we talk about technology's seat at the table, in essence. Some people think about that as artificial intelligence. I think artificial intelligence is one aspect of the fourth party. But if you look at what we did at eBay, when a buyer came to us and they said, I think I have a problem. I bought this item from this seller and it has not yet arrived. I think I might have been defrauded. Now, the buyer has not even communicated that concern to the seller. The respondent doesn't even know about this issue. But our software could then do an immediate investigation. And we would say, okay, what did the buyer buy from the seller? What kind of shipping did they pay for? Where are the two parties located? And what's the average shipping time between those two locations? Has the buyer ever filed a dispute before? Has the seller ever had a dispute filed against them? Did the seller buy shipping through our platform? Okay, yes, they did. That means we have a tracking number. We could use an API to go to the shipper and put in the tracking number, and we see, oh yes, the seller did ship the item and it's en route, and currently it's in Memphis, and it should be at the buyer's door in 3 days. And we could go back to the buyer and say, hello, buyer, we did an investigation. Here's your shipping number. The item's en route. It should be at your door within 3 days. If it doesn't arrive in 3 days, come back and tell us, and we can continue the process. And 99% of the time, the item would show up within 3 days. Now, why is that so powerful? Because the buyer never even notified the respondent they had an issue. We could do all of that in software, and it took a millisecond to do that investigation. So the more intelligence we can build into the fourth party, the more power we can have to identify these issues, do an investigation, reassure the parties. Now, say it's a more complicated issue. Maybe the buyer had received the item and they weren't happy with it. Well, then we can say, okay, tell us why you're not happy with it. Send in some photos. Would you be willing to accept this resolution? Would you be willing to accept that resolution? And we can structure the conversation between the parties to increase the likelihood that they will be able to achieve a mutually agreed upon resolution. And again, in none of these outcomes is a third party human neutral like a mediator or arbitrator required. In some small percentage, maybe 5% or 3%, a human can come in and add value. But if the software is working well in the diagnosis and negotiation phases, the vast majority of cases will be resolved before a human neutral is required. And as we get to the point of artificial intelligence and machine learning, the fourth party is going to become much, much more powerful. And it's going to be able to handle much more complex cases because the fourth party is getting smarter all the time. So I'm sorry, that was a long answer to a simple question, but I think it's worthy of further discussion.
Super interesting.
Yeah.
But 10 years ago, have I gotten you correctly? Even if the photos were requested, a human did not necessarily look at the photos.
Right. It was only in certain cases where the buyer and seller went through our whole process and didn't reach agreement. That was when a human third party, which was an eBay customer service representative, would come in, and then they would look at the photos, and they, in some cases, would evaluate the case and provide a binding outcome. But our goal was to make the volume of cases that went to a human as small as possible by making the earlier part of the process and the other thing we did was we put a lot of work, preventative work, ensuring that these disputes were resolved so that the buyer never had a concern. And that's the best way to resolve a dispute, is to prevent it from arising in the first place.
Great. Then before we hand it over to Martin, I want to just quickly get our viewers into the boat, so to speak, and just with a quick poll. We have prepared a small poll, 2 questions. The first one: have you ever had a conflict around internet shopping? With 3 different answers. And then, if yes, have you used any of the following to solve it? And of course, it will include as well private ODR as also the state procedures. So I ask my fellow, there it is. You just have to change in the right panel to Umfragen and then take part in the poll. And if you do so, you immediately see the outcome. Have you ever had?
What I often say, Julian, is I say to people, have you ever had a dispute on eBay or PayPal? And if they say yes, I say, did you get your money back? And they say, yes, I got my money back. I say, great, I built that system. That's why you got your money back. And then if they say, no, I didn't get my money back, I say, I left eBay and PayPal a long time ago and they've messed everything up. So it's not my strategy. Yeah.
So let's wait 20 seconds more. There are only a few votes coming in, but we're a little delayed. But it looks like, a few had problems with internet shopping, and then so it's hard to differentiate whether also the if yes is missing. So that's why there's the same amount of people participating in the second question, but at least some have participated, like 15 times more people have participated in PayPal and eBay than in the state procedure. So that was a quick interaction. So let's take it over to Martin and hear his view and perspective as a German researcher and what he has found. Martin, the stage is yours.
Thanks a lot, Julian. I have a look at the course of the conference throughout the last 2 days, and not everyone is here today or in this minute might have been present throughout the last couple of days. But basically what we've really been looking for is some improvements for state justice. And what we really lack and what we desperately need is some sort of success story for the civil judiciary. And what we've heard right now is basically it is a success story, even though it's not from inside the courts, but from outside the court. So what Godfather Colin told us is basically just a story of, I would say, like 2 decades of success. And in my view, the reason why he might have had so much success is that he has listened to the people out there. And this is, I think, something that we, if we want to try to improve our civil judiciary, can definitely learn from. I think our judges out there, I don't know how many judges are listening today, but they're doing a really, really good job in listening to people. And if you go to digitization conferences, one of the key takeaways always is there will be a lot of automation in the very end, but the one thing that we can't automate is listening to the people. And I think that our judges are, well, I don't know where they learn that, because they definitely don't learn it at the university, but they, in the end, they're quite good listeners. But maybe our law of civil procedure is not listening so well to the needs of the people who are trying to enforce their rights. And that is something that we can definitely improve. I want to remind you of a discussion we had here in Germany quite some years ago, when some leading academics in the field of civil procedure said, well, please, please, all the lawyers out there, please take into account that a civil procedure is very important. And there was a certain trend that the students at the universities should no longer have civil procedure as one of the core subjects in their law studies, but just have it as an elective that might then be chosen by only, say, 10% of them. And this discussion then kind of went away. But if we have a look at what happened in the last 2 or 3 years, it looks like a gigantic case for civil procedure. And this is a little bit of my background, but I think it is really a good time to live in for anyone who is into civil procedure, because there's so much to do. So there's no longer a discussion whether this is important. I could have set up a survey with you asking whether you think that the substantive law is more important than civil procedure or the other way around. But I would guess that most of you would say civil procedure is at least as important as the substantive law is. Now, if this is the time to live in for people like us, then the next question is, how can we really improve? How can we go on with what we find out during these days? And as I said, I think we definitely have to listen to people who were successful in what they're doing. And when I listen to Colin here, I have one thing that I notice. Because he says the vast majority of cases is handled and is finally settled in what he calls the earlier part of the process, meaning communication between the parties and try to clarify things and have a look in the system where the item shipped is right now and so on. And if I have a look at the civil judiciary as it stands right now, I would say there is no earlier part of the process. We kind of begin at a very, very late stage. And this is even something very different from it is not something that we have to see in the judiciary. Judiciaries and courts in other countries, they start at an earlier point of time. I think that Shannon will inform us later on how the Canadian process looks like, and I'm pretty sure that they start quite early and they have a ladder of escalation, and they try to let the judge decide only if no other option is possible. So it might be that we have to understand our procedure way more comprehensively than we do it right now. And then, of course, we'll have to discuss about things that we cannot imagine right now, but after having listened to such a conference like this one, we might imagine that some new techniques might come to what the judges do in their daily life. And this is the time for the first of my 2 surveys that I want to run on you, which basically asks whether you would like, after all of what you've heard at this conference, whether you would like to see Robo judges in Germany in the future. And if you now go to the Umfragen tab, this survey shows up right now. Should I answer the survey myself? I do, but I don't tell you what I voted. Oh, looks like I'm the majority vote. So right now I see that maybe 25% say no, we don't want to see Robo judges in Germany, and there are a couple of you who are kind of inspired by this conference, say, well, that might be the future. So we might go even one step further than maybe Colin has gone so far, and we really want to see maybe artificial intelligence in the judge's seat tomorrow, or say at least in 10 years. Now, I think this is very interesting to observe. At the same time, I think one learning you can take away from the whole PayPal, eBay success story is, and also of the success story of other legal tech companies that every one of you has already known before this conference, like Flightride and so on. We've seen people from these companies in this conference. One very key learning here is that you don't have to start with a Robo judge in order to get the digitization to the judiciary. What every legal tech company has done so far is that they have started with automating very, very simple tasks. So So it is an interesting question to ask what might one day be possible in the future, but we shouldn't stop to implement innovations just because we think in the very end it might be something that is problematic given our core values. But we should really start with the simple things and then see how we can step by step improve and improve and improve. That is basically what the legal tech companies have done in the last couple of years. Of course, we also have to keep our eyes open towards what might be feasible in the future. And here's my second question to you. I promise it's the last one. I don't know whether you have court experience, but many of you might have. Have you seen any Robo judges in Germany so far? Or would you guess there are Robo judges out there? And now I might be with the minority vote, I guess, looks like, even though I influence what you are voting right now by saying that. If you're following my legal tech lectures, you might know there are examples in the German judiciary where we do have little software helpers for the judiciary, and sometimes they're so sophisticated that they are able to tell the judge what he or she has to decide. For example, in the field of family law maintenance claims, it's basically just a calculation machine where the judge just takes the numbers from and then puts it in his or her judgment. And I think if we are talking about improving the judiciary with the means of digitization in the future, we also have to take account of what is present right now. And we shouldn't take the super ethical standards while ignoring what is going on in our courts right now. What we actually have is little subsumption machines, little digital helpers for judges, and we have them not because any parliament has decided that we have to have them, but because the largest German legal publishing house has decided to put them into their legal search engine and make them like an add-on to this search engine. So this, in my view, tells us that digitization is making its way, whether we want it or not. And what our task is as lawyers is that we observe what we can see if we have a look at what happens, and then without too high standards in terms of ethics and so on, try to develop a realistic view of how how a modern judiciary could look like. Who will be the player who will enact this in the very end? I guess that the European Union might play a very, very important role here because they are more courageous in terms of modernizing civil procedure. They've showed us that they're open to all these new standards by implementing their online dispute resolution platform, which, as far as I know, was also advised by Colin. And because also it looks a little bit like PayPal, I think this could be a good idea, a good way to work on a good idea, not to keep it outside the courts, but like to implement something like this online dispute resolution platform into what the courts of the member states do. So far, the European Union can do this only with cross-border disputes, but this should be one possibility to start with. So the whole field of flight passenger rights is a field where the German courts struggle, especially the courts around the airports. And it would be a very easy thing for the European Union to provide some sort of an online dispute resolution, PayPal-like platform to help these courts to get along with these disputes. And if anyone out there is working for the EU, please take this idea from this conference and persuade them to implement it. I would be happy to see something like the success story of Colin in our courts. And I'm actually confident that we'll see some of these inventions throughout the next couple of years. Thanks for listening.
Thank you, Martin. Yes, this would be definitely a great impact of this discussion if someone would have listened to and started to implementing that tomorrow. Now I hear myself. Maybe to begin with, Colin, or someone has the loudspeakers on, maybe?
I think it was Martin, and I think he turned it off.
Great. Yeah, Martin, I wanted to ask in a slightly different direction, because you mentioned now or emphasize steps the state or the EU could take to implement elements from PayPal, eBay, and copy the success, so to speak. In your papers, you also had a look at a different aspect of the whole thing, and mentioned that actually at the moment already what we have is kind of a PayPal law, and PayPal and eBay. Yeah, or maybe you want to explain by yourself what you meant by this, by referring to this PayPal law.
PayPal has this directive, they call it, Käuferschutzrichtlinie, those rules that tell whether somebody gets a refund of the money he or she paid or not. And sometimes it's very easy rules of thumb that you can write down on one paper, one sheet, or even in one line maybe. And this is basically our civil code written in only a few lines. So it's very trivial mechanisms, but in the end, it's a substantive law for the dispute resolution by PayPal. And if this law is so easy to administer, it might be a good idea for a lawmaker, for a state lawmaker, to think about whether it is possible to not trivialize the whole civil law, but at least think about making the substantive law here and there a little bit easier, because it's not only about whether law is just, it is also about whether the law is administrable, because if it's not administrable and if it's not enforceable because it's too complicated, it's of no avail. That is something we can definitely learn from PayPal.
Okay, great. Then let's move it on to Shannon. And as the chair of the Civil Resolution Tribunal, please, the stage is yours.
Thank you very much, Julian, and thanks everybody for coming this afternoon. So my perspective is a little bit different. I chair a public justice system component called the Civil Resolution Tribunal, and I thought it might be helpful to share a little bit of what that looks like to contextualize the discussion of how you can take some of the really fantastic kinds of tools and approaches that are used in private ODR and use them in the public justice space. And as we go along, I'll try to benchmark some of the areas where I think there is a divergence in approach between public ODR and private ODR. And then I really am looking forward to the discussion afterwards as well. So I'll try to share the screen. Please let me know when this is working. All right. Are you able to see the slides? Just a thumbs up. Excellent. Okay. So the Civil Resolution Tribunal is an administrative tribunal, which is a kind of uniquely Canadian common law vehicle, but it's kind of like an online court in the sense that we're part of the public justice system. And when people come to us, they are entitled to all of the benefits of the rule of law. And our decisions are effectively court orders, which can be appealed to higher levels of court. And because of that, we have to pay attention to certain things that private ODR platforms don't need to so much pay attention to. If the CRT, for example, was a startup that like Modria or like eBay or PayPal, it could pick its market segment because that's the right of any private company. You could choose who you are marketing your services towards. I could choose, for example, that we would only be providing or aiming our dispute resolution services at people who speak English as a first language, who have a certain income and education level and a particular dispute type. I wouldn't have to think about all the things I actually do have to consider as part of the public justice system. What are those things? Well, I primarily spend most of my time thinking about people who would fall through the cracks of our system. About 99% of people use our online platform with no problem at all. And I'll show you how that works in a moment. But I spend most of my time working with community advocates who represent and assist people who would not be very well served through the justice system currently, and also are at risk of falling through the cracks in an ODR system. So I think that's one of the key differences between private and public ODR. Public ODR has to work for everybody. There's no excuses. And that doesn't mean that you have to force everybody to use an online platform, but what it does mean is that you have to design around the needs of everybody in the public that you serve. So that kind of brings me to my blue bullet here, which is that I get invited to speak at conferences like this because of the online part of our tribunal, but I really do think that that's not the most important component. I think that the discussion about online versus offline is really misplaced in a lot of ways. And it's misplaced even more so in the pandemic age, where you see courts finally having to adapt to our circumstances by using technology, but they haven't done the fundamental work that I think is more important. What is that? Human-centered design. It's not about just spinning up a technology platform. It's not about forcing everybody to use the internet. It's not about digital justice. It's about fundamentally reimagining our civil justice system through the eyes of the people to whom it belongs, and then figuring out how we can bring it to them and build it around their lives. Digital platforms are one possible outcome of human-centered design, but there may be other tools that are better for some people. In fact, we know that's true. We're increasingly learning at the CRT that there's some segment of the population we serve who will never effectively be able to use the online platform, no matter how simple we make it, no matter how easy the language is. Those folks will need some human support at some point. There's also a group of people who we serve only by telephone or only by mail. And so I think the discussion about online versus offline is a bit misplaced. And I think to some extent, the discussion about private versus public is also not mutually exclusive, and I'll get to that. But I think it's helpful to frame at least this part of the discussion to say that our goal is not to force everybody to use a computer. Our goal is to leverage some of the tools that we now have in a modern society to achieve our greater aim of building the justice system around the public, all of them, every single person, and figuring out how we can best serve them given their unique circumstances. We have jurisdiction over a pretty wide range of civil disputes. We started with condominium disputes in 2016. So these are hundreds of people living in an apartment building, and they all own a small segment of that apartment building. And they are neighbors who have to agree on things. It gives rise to tons of disputes. So we started resolving those kind of neighbor disputes in 2016. A year later, the government gave us jurisdiction over low-value small claims disputes, 5,000 Canadian dollars or under. And I apologize for not having worked out the currency conversion for what that means in euros earlier. But ballpark, these are most everyday debt claims. It includes stuff you buy online mostly, things that you buy from on the internet through Craigslist or private seller to seller disputes, as well as some other neighbor disputes. So we resolved those for about a year, and then the government gave us jurisdiction over most car accident claims. And then that jurisdiction has also expanded this past year, so that basically if you're injured in a car accident in British Columbia, after next May, you won't go to court. You'll instead come to our tribunal. That's a really big expansion over time. So for all of these kinds of disputes, though, we've really built on the kind of work that Colin did with eBay. We've gone through a process of examining how these claims fit within the standard ODR template, and then we make changes where we need to. But basically, you're right, Martin. The goal is to slowly escalate the amount of human resources as the complexity requires that. So all people who have one of these disputes start with a really basic kind of AI type system called an expert system that helps to give them that legal information that you were talking about, that procedural information, but also the substantive information that they need in order to better understand what their problem is. Oftentimes people don't even understand that their problem is a legal problem, or they think it's a legal problem, but it might not be. So that's the first step. we try to give them tools to solve the problem on their own, so they don't even have to file a claim with the tribunal. If that doesn't work, though, they can seamlessly apply for dispute resolution. We serve the other respondent, because that's a difficult thing for people to figure out how to do. And when the respondent replies, the parties negotiate through something that kind of looks like WhatsApp or Facebook Messenger. And if they can resolve their dispute, we turn that into a court order for them. Most of the time, though, we need a mediator to step in and help. And that's where a lot of the heavy lifting happens for those complex disputes. Our mediator will take a temperature check. They'll look at what's gone on in the negotiation phase, and then they'll work with the parties to resolve their dispute through whatever mechanism works best for them. Last but not least is the judge type role. I'm one of those judge type roles in our tribunal as the chair. I'm a tribunal member. And we also have a number of other tribunal members, but they are not the focus of the tribunal. Unlike in the civil justice system, which is mostly built around the judge role or the trial role, we have really flipped that model. Why? Because we know that 99% of the time, a case that's even filed in our civil courts will not end up in front of a judge. And so we haven't built the whole process around that judge role. It just doesn't make sense empirically. So the tribunal member is there so that there's finality, so that parties who start the process know that they will get a resolution, but it's not the focus of what we do. The focus of what we do is trying to empower people to help resolve their own problems. And about 99.9% of people, as I said, do this through a smartphone on their couch. When a neighbor can help them, when a son or daughter can help them, when a friend can help them if they need help. But we also offer mail-based service, telephone help, in-person help as well. So it's really about trying to give people the tools that they need to solve the problem, given where they are. I don't have slides here to talk about this, but I think it is a really important point that the technology tool is just one tool. Some of the other things we do to try and even the playing field are ask people if they have hearing impairments or visual impairments or mental health issues or literacy issues. Optionally, they can tell us if they have a circumstance like that that might make it more difficult for them to navigate the process. And if so, one of our staff members will contact that person and figure out an accommodation plan. We also offer free telephone interpretation in 200 languages. We've created a special role for Indigenous participants because in Canada and in the United States, but I'll speak to Canada, we have an appalling history of cultural genocide against our Indigenous population in Canada. And part of our efforts at reconciliation and treating Indigenous people more fairly in our justice system for our tribunal has been to create a special navigator role who offers additional culturally appropriate support to our Indigenous participants. So in addition to those things, we also do things like write everything that we create at a grade 6 reading level. This is what our website looks like. A grade 6 reading level works out to be about the reading level of an average 10 or 11-year-old. That's the average reading level in Canada. And so everything that we create that any member of the public reads, whether it's an email from us, our website content, or anything else, even our judgments, has to be written at this level, and we audit that. So all of that is to say, none of those things are really technology solutions. None of those things are things that we do that are related to ODR. And this is what I mean by human-centered design. The technology can enable you to help people, but spinning up your trial through Zoom does nothing to increase access to justice by itself. Slapping an online discovery process or e-filing process onto your court does nothing by itself to increase access to justice. So my message is to encourage us to think more deeply about how technology should be used in the justice system. And it's not really about the technology. So just going to fly by this really quickly. This is what our website looks like. The first step is that question and answer platform I was mentioning. So people we ask people questions. They use radio buttons to give us the answers. And then we take them to legal information as well as self-help tools. And if you're interested in looking at this, feel free to go to our website because it's free to use and you don't need to have a dispute. We offer tools like this template letter that's already filled out based on the answers they've given us. So the goal, again, is not to get more cases in the door, is to give people the tools that they need to solve their problem in a way that's going to work for them. This is just a quick shot of our application form. I only pause to show you this because our application form and everything that we design is designed in partnership with the public. It's user tested with the public. It's primarily user tested with community advocates who represent people with disabilities, with literacy issues and other barriers to accessing justice. And I think when you start from that perspective, you end up with court forms which look quite different from traditional court forms. They're really simple, they're really basic. We make it so that it's really hard to misunderstand them. I'm going to skip over this because I've described the negotiation process already. Again, mediation is mandatory in our process. It happens through whatever communication method people want, and it is very human-driven. It relies on the emotional intelligence and the skills and abilities of our human mediators, even though they're providing this service at a distance most often. And then last but not least, we have adjudication. All of our staff work remotely, especially now. But even before the pandemic, about 75% of our 100 staff and tribunal members were already working remotely. What this meant is that during the pandemic, while courts around the world were shutting down or only hearing urgent matters, including courts in Canada, we stayed open without skipping a beat. We're open 24/7, and that continued during the pandemic as well. And we were able to focus on relocating our frontline staff home in early March, and then they kind of seamlessly did that, and we pivoted to thinking about how we could help parties who might be in distress. So because we weren't just scrambling to figure out how to keep our virtual doors open, we were spending time communicating to people that if they needed extra time because of the pandemic, they could just send us an email and all kinds of other things like that. So one of the benefits of being remote is that, and one of the benefits that we experienced during the pandemic is that because the tribunal was designed for people with the most barriers, it was able to be flexible enough to accommodate the fact that instead of 10 or 15% of people having those barriers, suddenly many more of us were having those same barriers, right? When you think about those barriers, they tend to be economic or mobility. You can't get down to a courthouse. You have difficulty leaving your house, maybe because of disability issues or mental health issues. You maybe don't have money to find legal help or to be able to get at certain services or solutions. Well, those are things that many of us are kind of getting a taste of now. And so if you design a system that's flexible enough to accommodate people with the most complex needs, then it turns out that'll stand you in pretty good stead during something like a pandemic. Our decisions are all published online. They're also uploaded to our national decision database called CanLI. And I think this is really important in terms of transparency as a public justice actor, in terms of knowing how decisions are resolved and how they're decided, but also as a public information tool. Many of our decisions end up being the subject of newspaper articles. Why? Because they're written at a grade 6 reading level, which is also the average newspaper reading level, and because they tend to have interesting fact patterns, but also because we're publishing them very quickly. So within 24 hours of sending the decision to the parties, usually by email, they're also uploaded onto our system. Just lastly, we also survey people who have gone through the process to ask them what they think of it. And we tend to get very high marks for things like fairness and would you recommend the process to others. And I think that's a really helpful source of feedback for us. And it feeds into our mantra of continuous improvement. We're always looking at ways to change and adapt. So with that, I will just wrap up because I think I've gone a bit over 10 or 15 minutes. But if you'd like more information, have a look at our website. We're pretty active on social media as well. And we publish those monthly statistics on our website if you want to take a closer look as well. So with that, I'll hand it back to you, Julia.
Thank you, Shannon. Thank you for your talk and your insights. Really interesting. Just three more questions to detail before we get into the discussion. Just a quick question about the duration of your processes, because Colin was stating earlier on 12 days was a lot of time for eBay, and no state court could ever reach those kind of regions. But it would be now interesting to hear what you can do with your tribunal. Sure.
Well, we do not resolve disputes in 12 days. That's for sure. But we do resolve small claims in a median of 59 days last year. And by comparison, the court that hears the next level of small claims, so we have jurisdiction over 5,000 Canadian dollars and under, the court that hears the claims over $5,000, on average, they take about a year. So even day one, we were much faster than the court. And we constantly are looking at analytics to reduce our timelines. Now, that's the median time. So that doesn't include cases that resolve just through negotiation. That can happen within a few days. And in some ways, that's more akin to what Colin was describing. If you have to go through a process of exchanging evidence and submissions, especially as part of the public system, procedural fairness requirements will require you to take some time. Our goal is to viciously eradicate administrative delay on our side while being incredibly generous and flexible with the parties. We want the parties to be able to have the time they need to do what they need to do. But we are ruthless internally about finding backlogs and delays and ways that we can automate routine business processes on our side.
Great. And I want to try to bridge the thing you said, that it's actually not about digital courts or online courts. It's about human-centered design. But I was asking myself, is there not still a connection, because it's such an important access to the process, to be able to do it from the couch in the living room and just kick off the process. And also it's an opportunity to redesign the whole putting the processes online is like an opportunity to also think about user-centered design and this whole thing, thinking digital first. We heard this a lot the past days. It's not about translating analog processes into digital, but start thinking fresh and new. So there is a coincidence between taking justice proceedings online and human-centered design. Is there not?
Yeah, I agree with that. And I think that's really the true gift of ODR, is that it's the gift of a blank slate, right? Because ODR requires you to fundamentally reimagine outcomes and processes. And if you're going to do that, what better way is there to start from empirical evidence and also user-centric approaches? So if you're unburdened by having to do things the way you always have, then you have this gift of being able to think imaginatively and creatively and frankly, humbly about how we design the justice system. If you were to design it from scratch tomorrow, you wouldn't design anything that looks like what we have. You'd probably scrap about 95% of it and keep the fundamental legal principles, like the rule of law, like procedural fairness, and really change almost everything else, or at least I probably would. I would certainly get rid of a lot of the gowns and the oak paneling. But so you're right that technology is a tool, is also an invitation to think critically about why we do what we do. That said, I've seen many jurisdictions use technology in ways that do not increase access to justice, in my view. And it's a missed opportunity. We talk about paving the cow path. We talk about digitizing analog processes. That is the easy route, right? Because it doesn't require you to have to do this difficult, humbling, frustrating often work of human-centered design and process redevelopment. And I think there is also a culture problem that can contribute to that, because we have this idea as lawyers and judges that we are the experts, that we know best. It's very much part of our identity in that way. And doing human-centered design requires you to be constantly wrong, to admit that you're not the expert, to acknowledge that you may know the law, but you are not an expert in people's human experience, and that you have to step back and step out of the spotlight and allow the users to be the center of the focus. And that's a really difficult thing culturally for a lot of legal cultures in different jurisdictions to do, including in Canada.
Great. So let's open the discussion, and I want to quickly play back the ball Shannon has taken up, saying, yeah, we can't leave anyone behind. The justice system is for everyone, and this is something private systems couldn't do. And as opposed to that, Colin earlier on said he wanted, with eBay, PayPal, and even in the early days of Moria, stand next to the courtroom and saying big big letters, don't go in there. So, Colin, what's your answer on the remarks of Shannon?
Well, Julian, I'm going to take your bait and I'm going to play this private public dichotomy out a little bit more, but I'm going to preface what I say with an acknowledgement. If I could wave a magic wand and make Shannon Salter head of the global legal reinvention effort, I would do so without hesitation. She is absolutely the best actor, and I'm humbled by the seriousness with which she has tackled these challenges and the progress that she's made. You know, I've worked with dozens of courts around the world and in the United States trying to get them to refine their ODR strategy. And as I said, the CRT is the high watermark. I've never seen anyone do it as well as she's doing it. So we are looking in her example as what I think is the best example that you can give of how to use technology to reinvent the public justice process. That said, you know, in Germany, you're saying as well that filings are going down while you see these ODR filings going up. Now, look, I know a lot about different justice systems around the world. The German justice system is one of the most efficient and trusted justice systems in the world. And you're still seeing people vote with their feet. We're doing a lot of work in India. In India, the average time for resolution for a civil case filed in the court is 10 years from filing. Okay, some of these cases take 16 or 20 years. You have people that pass away and they will the case to their descendants so they can continue to pursue it in the courts. There are many courts around the world, and in the United States, we are nowhere near the efficiency of the German justice system or the Japanese justice system. We have a crisis of self-represented litigants. We have a crisis in access to justice. We have chronically underfunded legal service programs. So what I don't want to do is criticize what Shannon has come up with and said, well, that's not good enough, because she's doing absolutely the best that you can do. If you look at what's happening around the rest of the world and you take a very clear-eyed assessment of where the public justice systems are, they're falling short, particularly when it comes to these low dollar value civil caseloads where people can't get a public defender. I mean, we could talk about the criminal side. That's a whole separate ball of wax. What I'm saying is, think about the truly disruptive innovations that have occurred in technology. Think about the Airbnbs, think about the Ubers, think about the Googles, think about the Amazons. How far would Airbnb have gotten if it was selling its services to Hilton and Hyatt and Marriott? You know, those are the incumbent players. So if Airbnb was selling its services to those companies, they would have smothered it in the cradle, because they don't want that disruptive innovation. How far would Uber and Lyft have gotten if they were selling to the taxi associations? They wouldn't have gotten anywhere. So the problem is, when we talk about legal tech and we say, oh, we're going to create a startup and we're going to sell to the courts and we're going to sell to the judges and we're going to sell to the law firms, they have no incentive to innovate, particularly because the public justice system has a monopoly. You cannot go to the courts and say, well, I don't like this court, I'm going to go to this other court. So what I'm saying is, it's not that what Shannon is doing is not adequate. She's doing a fantastic job. What I'm saying is, if you really want to see this new, truly innovative, blank piece of paper system, and this is taking Shannon's concept of human-centered design to its logical conclusion. I think if you really listen to what users want, they don't want courts. And you can make them a better and better, and streamline it and make it online, and, you know, put someone great like Shannon in charge of it, but still they are going to vote with their feet, because eventually what they want is this all, you know, 24/7 available, fair, consistent, accessible. And yes, there's always going to be people that can't use technology, but the percentage of people that can't use technology is getting smaller and smaller each day as these systems become more accessible and more powerful and more competent. So just like we don't want the public system building our self-driving cars, we want private companies innovating and making them better and smarter and faster all the time. That's the kind of innovation we need in the justice system to truly deliver on human-centered design and build a system that can provide fast and fair redress for individual consumers on the time scale and the costs that they want, which is free and instant. And I don't think that the current justice system is going to be able to do that, no matter how well you evolve it through human-centered design. That's my contention.
But even not if it's done like Shannon did, or would you say, no, that's the exception, that's the gold standard? If the state courts would do it like that, then people would not leave because they had no reason, because they can do 24/7, they can get their process going from their couch. It's all online. They can call if they have problems.
No matter what question you ask, you're not going to get me to criticize Shannon and the CRT. But I will say, I think that this new vision of where justice is going is more what citizens want. And even in your poll that said, we don't want to have digital judges, Martin's poll, we don't want to have digital judges in Germany. Well, let's do that poll again in 10, 15 years, because the culture is changing. We're doing things online that 10 years ago, we would have thought we're never going to do that online. Online divorces and all this stuff. Now it's commonplace. So the culture is changing. And I think we need to build the future of justice, not where we are today, but where we are going. And it is not hard to see where we are going. So let's embrace that change and get ahead of it, as opposed to being reactive, as opposed to having our customers, our citizens, our disputants coming in and saying, why do I have to drive down here? Why do I have to do this phone call? Why can't I just do this online? I mean, Shannon's taken it a long way, but it can go farther. That's what I'm saying. So
if I could just jump in there, Julian, unless
sure.
you're going to throw it to Martin, then I'll let Martin talk, I promise. But I it's not my position that every single dispute needs to go through the public justice system. Quite the opposite. I think we would be well served by having a much more diffuse approach to dispute resolution. The idea that if you're somewhere and you can do it fairly, you should do that, whether it's through ombudspeople or agencies or even private systems. My fundamental anxiety, though, is that if the public justice system means something in a democracy, if it is something that we value, the idea that there should be some, rule of law, a legal order that you can turn to the state to enforce, then that has to mean something. That has to have some content. And it is an open question. What is the core of that content, and what can we afford to spin out into public or sort of private platforms? But at the end of the day, I think the reality is, and Colin's kind of getting to this, is that what's created a market for these private ODR platforms is the fundamental failure or inability of the public justice system to provide people with the access that they need and want in a modern context. And arguably, they haven't been able to do it, even not in a modern context. And so I actually lay quite a lot of responsibility for this at the feet of the public system. And I've been to no end of legal conferences that are populated by judges and lawyers who tisk about ODR and, well, you can't do this and it's not that, it's not the gold standard, and I need to look at the whites of somebody's eyes and so on, none of which is empirically backed up. And then in the same day, I'll be on a panel like this where it's already happening. They are seeing that they are losing. They're not seeing that they're losing market share, and so it feels like rearranging the deck chairs on the Titanic a little bit. And I feel like saying, if you value this public system that we're all part of, there's a reason I work in the public system, then we need to modernize it. Otherwise, it's going to not exist. It is hurtling towards obsolescence, in my view. And that's why I'm so passionate about making sure that there is some way that the public system continues to exist, because I don't think, as well-intentioned as private ODR platforms may be, they are not designed to be able to accommodate everybody. And people who cannot afford to use them or aren't buying the thing that enables them to use them still need to have an accessible justice system when their landlord kicks them out. When they are not given the benefits to which, social benefits to which they are entitled, when they get taken advantage of, and so on. So that's my little rant.
Martin, if you imagine a Germany that would have already installed a tribunal like Shannon with all these 4 steps, with this filter and this huge human-centered design and a digital access, can you imagine, do you see still, what role do private ODR systems and the private sector with its conflict resolutions remain in your view? Is there any, or is there not?
I actually wouldn't try to push them back at all. I think there are, even in 10 or 20 years from now, there are enough disputes for everyone. So even with a vital and strong judiciary, I'm pretty sure that all the Alibabas, Amazons, PayPals have enough disputes to solve. So that is not the problem, I'm pretty sure.
And maybe also connected with one of our other speakers, Cord Brückmann, I think he's also listening. He also said, let's embrace also the private initiatives to raise access to justice, and it's part of the solution and not part of the problem. And he also saying many people, they prefer to get 80% realized of their substantive law now than 100% in months of a time. And even if you can reduce months, as we heard from Shannon, it's still 2 months. So Martin, and you said, yeah, but also the state maybe can learn, and for certain areas trivialize the law or make easier rules. So is this something only the private can do, or is also the state able to say, okay, we lower our standards of procedure, our standards of substantive law we need to make the decision with in order to reach a really fast and cheap or even free decision? What do you think? Because traditionally thinking from a German jurist, this is far from what I understand as a constitutional state. So there might be this is where I see the role of the private maybe, but I'm interested on your perspective.
Well, I'd say it will always be easier for the privates to do that, but that doesn't mean that the state cannot at the same time try to get a little bit more human-centered than he is right now. So, of course, to work with very general standards of fairness, in my opinion, must be easier for privates because they are not so bound by a procedural law and so on. So, and they are much more flexible, and they will be in future. But that doesn't mean that, as with the procedure, that the state cannot learn at least a little bit from them.
Great. Any thoughts, Colin?
Yeah, one of the things that I do want to point out, and I'll say a weakness of the private model of creative destruction, where we have all of these ODR initiatives cropping up and some of them succeeding and some of them failing. You have a lot of innovation, but you also have the potential for bad actors. And I think it's very easy for us to imagine an ODR mechanism that crops up that doesn't have the interest of its consumers at heart. Maybe they collect information from the parties and they say, we're going to keep this confidential, and then secretly they share it on the back end with the businesses because they're making profit. So we've created an organization called ICODER, the International Council for Online Dispute Resolution, that has established standards of practice, auditing requirements, certification, so that we can try and provide some way to ensure that all of these new ODR mechanisms can be measured against a yardstick, a publicly enforceable yardstick of performance that we require. Now, one of the things that I will say is, we estimate there's, as I said, there's more than 1 billion cross-border transactions that are generating ODR disputes. As Shannon said, even in the United States, only 98% of cases filed into the civil courts never make it in front of a judge. Okay, that means the parties work it out, they resolve it, they give up. And my estimation is 98% of this disputes in broader society never get filed in a court in the first place. So you're only talking about 2% of the cases making it into a court, and then you're only talking about 2% of those cases ever getting in front of a judge. So when we talk about the elephant, we're talking about the toenail of one elephant is what gets in front of a judge. So I think it's what we're saying in the private sector is, let's get really efficient at resolving these disputes. As Shannon said, at the point where the dispute arises, earlier resolution is always the best kind of resolution. But you always have to have a public option as an absolute backstop. And it's never going to go away for the reasons that Shannon said, because there are people that fall through the cracks. There are cases that just can't be resolved through those mechanisms. So even if you're talking about 1% of 1%, we still need a public justice system to handle those. But let's build a really robust private online dispute resolution panoply of options that can provide that early resolution and prevent disputes. So if we get to the point where it's only a tiny trickle of cases that are making their way into the courts, that means the private sector is succeeding. And in the United States, we actually have the Supreme Court is passing decisions that are saying you can now say in a contract, we agree this will never go to court. Like when you get your cell phone service or you open a bank account, it says in that contract, this will never go to court. We can only resolve this through private dispute resolution. And let me be clear, I do not support that. I think that's a terrible idea. But I want the private sector ODR options to win on the merits. I want to resolve 99.999% of those cases, but I always want the parties to have the right to go to court if they want to. I just want them to not want to, because our systems are so efficient and so effective. And then we can have a system that runs as well as Shannon's systems run to handle that, 0.01%.
Yeah, I think it's worth pointing out too that access to a lot of legal technology is a luxury good, right? That's not the case with eBay or PayPal or even Amazon or Alibaba, where people buy toothbrushes and they can engage in dispute resolution with respect to that. That's pretty accessible for many people. But what I'm seeing increasingly is in the conversation about AI and scraping judicial decisions to try and predict what a judge might do in a particular case, we have a lot of public discussion about that and robo judges. But quietly, large law firms, multinational law firms, already have those algorithms that they use for their specific clients. And so I don't think it's about throttling legal technology at all or private ODR providers. It is about thinking that some of our rarefied principle discussions in the public sector about access to these technologies or access to online dispute resolution inherently is elite, because people are already buying their way into those options. And so what we talk about in the public sector is that cohort of people who would never be able to afford to hire that law firm and take the benefit of that predictive analytics, or would never be able to use a dispute resolution platform in a family environment because it was too expensive. And they're the ones who are stuck with the public system. And that's what I want to make sure evolves. So to be clear, I am not faulting private ODR platforms or legal tech. I think it's a thriving, exciting industry. I just want the public system to start taking away some of their market share by being a reasonable place for everyday people to resolve everyday civil disputes.
Maybe, Colin, you can briefly elaborate on the rules you agreed on in the institution. You just said that you have acknowledged that they are necessary to provide for a trustworthy private ODR.
Absolutely. I encourage everyone to visit iCodr, ICODR.org. All of the principles and best practices are available on that site. One of the things that Shannon talked about in those principles that we are promoting through this global community of ODR practitioners and academics, we say things like, ODR should be free to complainants. It has to be accessible, meaning it has to be designed so that people with different ability levels can access it, so that people with different reading levels can access it. It has to be available over mobile devices. Having these standards and best practices out there, I think, get us closer to what Shannon is saying, which is expanding access, expanding fairness. We say it has to provide a level playing field. It can't be partial to one side or the other. It has to protect the personally identifiable information of the parties, because that's one advantage, again, of the private sector, is we can maintain that confidentiality, whereas private sector solutions obviously are subject to different rules. So I do urge you to go check out iCodr. And, for instance, in India, the Reserve Bank of India, which is really their largest financial institution, has now required that all payment providers in the country offer ODR. And there's a scramble in India to create all of these ODR mechanisms, because the government has already started outlawing paper currency. So everything is moving to digital payments. We're talking about more than 1 billion people who are all going to get access to their own resolution centers. So now iCodr is working with the Reserve Bank of India to come up with these standards to establish a yardstick through which the efficiency and effectiveness of these mechanisms can be measured. So that's the kind of industry organization that we can do to hopefully address some of the issues that Shannon is identifying. And if we can provide free, easy to access, fair, impartial, transparent, monitored ODR, I think we can do a pretty good job. But there always has to be that public option as a backstop if somebody falls through the cracks or those mechanisms don't work for them. So I think we're going to see a lot more initiatives like that around the world. Right.
Shannon, from our viewers, there has been the question how the CRT was started, who took the initiative, and also the process of including players like the Anwaltschaft. Now I'm missing an English word. The lawyers, who have been used to work with a whole different system. Maybe you can tell us a little bit about these things.
Sure. So the idea for the CRT was around before I was appointed chair. It was the idea of one of the leading ODR experts who were lucky enough to have in British Columbia, Darren Thompson, along with his colleagues in the Ministry of Justice here in British Columbia. And as Colin mentioned earlier, there were some early collaborations with Colin's technology, with Modria in British Columbia, through consumer protection and property assessment platforms. So there was already some seeds planted. And the ministry, though, really took on the idea that there had to be a better way to solve these neighbor disputes in these apartment buildings. They were really keen, just as Colin's described, to have a way to resolve these annoying problems without having to go to our superior court. So that was really the genesis of it. And this group in the Ministry of Justice managed to get legislation passed to create the tribunal. And that's in a nutshell how it came to be. The other part of the question was about lawyers, I think. Initially, and even now, this is popular among some lawyers and not so popular among other lawyers. One of the things that really frustrated lawyers is that in the legislation, there is a rule that you cannot have a lawyer for condominium disputes and small claims, the 5,000 and under disputes. For car accident disputes, you can have a lawyer if you want to. So that was not very popular with lawyers, as you can imagine, even though lawyers were not doing this kind of work anyway, because there was no money to be made representing somebody about the neighbor's barking dog. The expansion into car accident claims has been a huge change for lawyers. We have a full tort system in British Columbia, or will have until next May. In British Columbia, lawyers make $1 billion a year in legal fees related to car accident claims. As of next May, all of that is over because of the changes that have been made. In part, those changes include bringing that jurisdiction in the CRT. So I think I'll just leave you to connect the dots about how lawyers might feel about that part of the changes. But it is disruptive. That said, I teach in the law school here at the University of British Columbia. And one of the things that I present to the students is that there is a real opportunity with ODR too to find a different way to practice. It may not look like being in an oak paneled law office downtown. It might look like what I'm doing now, what we're all doing, sitting in front of a computer, figuring out what your value proposition is. And maybe that's not full representation, but it might mean a bundle of services that you can highly automate to provide remote advice, remote template materials, advice on mediation or negotiation, and package that up in a way that it's sustainable for you, that you're not working 90 hours a week, that you're able to see your kids, you're able to have a balanced life, you're able to work from home, you're able to keep your overhead low. But there is an opportunity, especially for that new generation of lawyers, to be really entrepreneurial about how they engage in a legal community that's quickly changing.
For sure. Martin, you said in the beginning or in your talk that the state should learn a lot from private ODR. And I think you would agree that Shannon with the CRT has done so. And I was just summarize a few things. So this human-centered, also digital online entry is certainly one thing. Thinking digital first and from scratch, designing a whole new court. That's what they did, and not waiting for a perfect solution. And there I have a nice quote, Shannon, if I may, from another YouTube interview. You said, "Failing fast and forward." And this is certainly certainly an unusual way to think for policymakers and reformers. But Martin, with these things in mind, where do you see an area in the German context where we could try these things out, like in the not so distant future, or actually now, and experiment and not making any damage?
I could think about a lot of fields of law. One that we've actually seen not so far from us in the Netherlands is that they have experimented with online divorce. Colin has also mentioned that some minutes ago. And I would say that is a field of law where we are more analog than anywhere else. And I would say that there are many opportunities if we try to digitize the whole divorce process. That doesn't mean that there's an AI judge or a computer software that basically divorces the couple, but that means that we try just to prepare the whole court process so that in a digital way, so that everyone can sit back in his living or her living room and collect all the documents that you need and upload them and do the whole preparation guided by software. There we can learn a lot from what we've heard today from Shannon and Colin. We can also learn a lot from what they worked on in the Netherlands and other countries. And that would be one of very many examples where we might want to give it a try.
That sounds good. With that being said, I would try to just briefly summarize what we have discussed and heard in the past almost 90 minutes, and then we will end on a short final statement. So our main questions were whether the development or the rise and gaining significance of private ODR was a bad or a good development or something in between. So we heard slightly different opinions on that, but I think with an agreement that there's enough disputes for everyone, and that the public should always remain as a last instance. And about the degree, I think there might be slightly different opinions that we heard. And the second one about the rules. We heard that there is actually already an organization of private ODRs who have discussed on rules, and we talked a little bit about impartiality, about data protection and fairness, monitoring as well. I would have had a lot of questions more on this, but it's such a short time. And can the state learn something from eBay and PayPal? Yes, a whole lot. And at the center is the user-centered design. I think this we can take as a summary. And let's end on a short note. What our speakers wish for a justice system 2030. I asked them beforehand, and maybe Martin, you can start, and then we go on.
So I would say try to listen to those who've managed to bring their attempts into success, and try to maybe build a network between them and our Ministry of Justice, and try to persuade people up there one by one that it might be worth thinking about improving justice. And maybe not only try to work in very tiny little steps within the existing systems, but sometimes also try to set up a new system in maybe a regulatory sandbox or something, just to see what can happen if you try to implement a whole new idea without anything that impedes you from the procedural difficulties that we've come along with throughout the last hundreds of years.
Right. Shannon, what do you wish for a justice system 2030?
Well, my vision of a justice system 10 years from now, hopefully, is one that is fundamentally reimagined, where we change the culture to be curious, to be humble, to really think about the most vulnerable members of our society and design around them first and foremost. One that really is empirically based, that looks to good evidence and information and not just assumptions and anecdote in making policy, in designing systems. And I think if we did that, whether that leads us to a combination of technology or offline solutions, one way or the other, I think would be a huge step forward. And I think there's definitely room there for private systems to thrive as well.
And that's your Stichwort, Colin, take it on.
Thank you. I get the final word, I guess. Well, Martin Luther King said the arc of history is long, but it bends towards justice. And I think one of the things that I've seen over the course of my career, I got the gray hair to show I've been around for a while, the science fiction stories today are the commonplace realities of tomorrow. Technology is just a tool. And it can be very scary, and it can be destabilizing. But if we embrace these tools and we understand their promise and potential, they can help us deliver on our core values, which won't change, which is justice for all and fairness. And I think that there is a future ahead of us if we use these tools correctly, where we have better access to justice, we have fairer outcomes, and a better civil society. So that's what we all need to do, is work together to ensure we use the tools the right way to get there.
Work together for better access to justice. What great words to conclude the session. Thank you very much, Martin Fries, Shannon Stolzer, and Colin Rule. It's been a great discussion. And yeah, thanks for taking the time. Everyone else who's watching, please stay in the line. We will have a last talk within the Record Law members, what we've learned in the conference the last 2 days. And we will just change the speakers. Say goodbye to Martin, Shannon, and Colin. Thank you very much. And let the other Record Law members come in.
Thank you.
Goodbye.
Stay well, everyone.
So jetzt kann ich ja wieder auf Deutsch wechseln. Und bitte euch um 1-2 Minuten Geduld, bis wir uns hier versammelt haben. Jetzt kommen noch die anderen dazu, teilweise hier im Raum und teilweise digital. Und genau, dann machen wir auch noch das Gewinnspiel. Wir hatten ja noch 3 Bücher von unserem, da sind schon die ersten 3. Genau, ich hatte gerade das Gewinnspiel schon angekündigt. Wir hatten noch 3 Bücher, Neustart verlost, herausgegeben von Herrn Heilmann und mit ganz vielen Beiträgen von MDBs. Ramona, vielleicht willst du übernehmen.
Ja, sehr gerne. Vielen Dank, Julian, und auch nochmal an die 3 Speaker zu unserem letzten Panel. Das war ja auch nochmal eine wirklich sehr runde und abschließende, gute Diskussion. Weil du gerade schon die Verlosung angesprochen hattest, dürfen wir nun auch die Gewinner ernennen, beziehungsweise das ist im Hintergrund schon passiert. Und gewonnen das Buch Neustart haben René, Adrian und Isabella. Herzlichen Glückwunsch an euch. Wir werden nochmal gesondert auf euch zukommen via LinkedIn, Instagram und per E-Mail. Und in diesem Rahmen auch nochmal ein großes Dankeschön an den Finanzbuchverlag, der uns die 3 Bücher zur Verfügung gestellt hat. Super, da ist jetzt auch schon Yannick. Julian ist, glaube ich, kurz einmal weg. Jetzt warten wir noch auf die 2 anderen Moderatoren und dann wäre das fast komplett. Sonst können wir vielleicht auch schon mal starten. Und zwar der Plan nun ist, die letzten beiden Tage nochmal Revue passieren zu lassen. Und wir möchten nochmal die Moderatoren zu Wort kommen lassen mit der Frage an Sie, welche Erkenntnisse ihr von den letzten beiden Tagen mitnehmt. Also was nehmt ihr sozusagen ja als Key Fact aus euren Panels, aus euren Impulsvorträgen und allgemein von der Konferenz? Vielleicht, Pauline, wenn du möchtest, kannst du ja starten.
Genau. Ja, ich glaube, gerade an meinem Panel hatte ich den Eindruck, dass die Corona-Pandemie für alle Beteiligten als auch Impulsgeber wahrgenommen wird, also als eine Chance, wo wir im Grunde jetzt die Möglichkeit haben, wirklich eine übergeordnete oder eine umfassende Digitalisierungsstrategie in die Wege zu leiten, die im Grunde Politik, Justiz und hoffentlich auch IT-Experten vereint. Gleichzeitig, was aber auch mein persönliches Fazit zur gesamten Konferenz wäre, jetzt unabhängig von meinem Panel, ist im Grunde, dass die Digitalisierung der Justiz an 2 Fronten gekämpft wird. Also nicht nur bezogen auf die digitale Justizverwaltung, wo es eben darum geht, schneller und digital zu arbeiten und im Grunde bisherige analoge Abläufe zu digitalisieren und effizienter auszugestalten, sondern auf einer zweiten Ebene sich auch zu überlegen, wie man im Grunde grundlegend beispielsweise das Verfahrensrecht, das haben wir in einigen anderen Diskussionen auch gehört, im Grunde verändern muss und zum Beispiel auch, wie Digitalisierung die richterliche Tätigkeit verändern wird. Und ich glaube, gerade da klang immer mehr durch, dass es da sich nicht nur um marginale Änderungen handeln wird, sondern im Grunde fast schon ein disruptiver Charakter eine Rolle spielen wird. Und das war auch mein Fazit zur Conference, was ich besonders spannend fand.
Super, vielen Dank. Vielleicht als nächstes, weil der Herr Dr. Steffek auch als nächstes im Programm war. David, dein Fazit, deine Erkenntnis von diesem Vortrag oder von der Konferenz allgemein?
Ja, ich konzentriere mich auf den Vortrag von Professor Steffek und was ich interessant fand, was mir besonders hängen geblieben ist, war das Thema, dass er darauf hingewiesen hat, dass KI und Richter und Justiz nicht immer nur, dass die KI ersetzen kann, sondern dass die KI auch jetzt schon Juristen, Richtern dabei helfen kann, bessere Entscheidungen zu treffen. Also wir das nicht immer in so einem Ausschließlichkeitsverhältnis sehen müssen, sondern eigentlich das schon jetzt dabei helfen könnte, bessere Entscheidungen schneller zu treffen. Das habe ich vor allen Dingen mitgenommen, neben ganz vielen anderen, aber das war schon in dem Vortrag von Professor Steffek ausreichend beleuchtet.
Vielen Dank. Als nächstes kam dann der Vortrag von Herrn Heilmann und da warst du ja, Kai, der Moderator nachher auch der Fragen. Was war dein Impuls oder deine Erkenntnis, die du mitgenommen hast?
Ganz genau, danach kam Herr Heilmann. Herr Heilmann plädierte grundsätzlich in seinem Impulsvortrag für einen Neustart, wie ja auch das Buch heißt, das er unter anderem veröffentlicht hat oder mitgeschrieben hat. Und in diesem im Rahmen dieses Neustartes soll es eben um eine schnellere Digitalisierung gehen und insbesondere auch des Verwaltungsapparats. Dabei hat er einen weiten Überblick gegeben und auch im Detail erklärt, was er sich darunter vorstellt. Ein Grundbaustein, wo er großen Wert darauf legt, ist eben das IT-Fachwissen, was auch in dem Verwaltungsapparat die Führungspersonen haben sollten. Dabei geht es um ein weites Verständnis und nicht darum, dass sie jetzt programmieren müssen. Darüber hinaus plädierte er dafür, dass die Prozesse vereinfacht werden müssen, beziehungsweise neu gedacht werden müssen, sodass sie digitalisiert werden können. Dabei schlägt Herr Heilmann ein Ministerium für die Digitalisierung vor, um letztendlich diese schnelle Digitalisierung im Rahmen des Neustartes zu erreichen, was diesen Schritt erfordert einen insgesamt großen Mut, den wir erfreulicherweise in den vergangenen Stunden und auch gestern schon aus den Vorträgen und Diskussionen dieser Konferenz herausfinden konnten.
Ja, vielen Dank. Das war soweit der erste Tag. Johann ist leider verhindert, er kann jetzt aktuell nicht sich hinzuschalten, aber auch nochmal zu dem Panel. Vielen Dank, beziehungsweise zu dem Interview. Dann ging es heute Morgen mit dem Panel 2 und mit dem Panel des zweiten Tages los, The Tomorrow's Online Courts. Yannick, du hattest da die Moderation inne. Was waren deine Erkenntnisse?
Oh nein.
Nee, hörte ich noch nicht?
Bitte nicht. Nein.
Versuch's nochmal. Na, ja, vielleicht jetzt.
Den anderen vielleicht auch noch rein.
Mit Herrn Thome weitermachen. Ja, sonst sage ich was
Genau.
zu Herrn Thome, genau, mit dem ich das Interview geführt habe. Ich denke, wie auch im Panel am ersten Tag kam dabei hervor, warum sitzen wir hier gerade alle vor unseren Bildschirmen und sind nicht physisch irgendwo anwesend? Warum diskutieren wir dieses Thema gerade so heiß? Das ist eben die Corona-Krise, die uns jetzt den Impuls gegeben hat. Und dennoch, trotz der Einschränkungen, hat eben in der Corona-Zeit es ist nicht zu einem völligen Lockdown gekommen, also nicht zu einem Stillstand der Justiz. Sie hat weitergearbeitet, was auch gerade an der Initiative Einzelner lag. Und ja, jetzt müssen wir eben uns darum kümmern, das System und die Strukturen drumherum so zu verbessern, dass diese Schwächen, die aufgedeckt wurden, in Zukunft abgestellt werden. Und da bedarf es laut Herrn Thome eben gerade, was die Ausstattung angeht, aber auch den gesetzlichen Rahmen, musste einiges noch verändert werden. Und ja, einen Aufschlag hat er dazu gemacht. Wir haben auch darüber gesprochen, über den Antrag eben seiner Fraktion im Bundestag, 128 AZPO ins Benehmen der Parteien zu stellen. Und das Zweite war, worüber wir gesprochen hatten, wie man die Öffentlichkeit tatsächlich auch im mit Zustimmung der Parteien im Internet live streamt, die Verhandlungen. Genau, das waren so die wichtigsten Punkte, die ich mitgenommen habe, und ich hoffe, ihr und Sie auch.
Super, vielen Dank. Jannik, vielleicht probier's nochmal.
Ja, sehr schön. Ja, genau. Also ich habe eigentlich 2 Punkte, die ich so mitnehmen konnte. Und zwar der erste Punkt ist, dass die Justiz von morgen einen erheblichen Digitalisierungsbedarf hat, um gerade auch mit den Alternativen und den Online-Schlichtungsstellen mitzuhalten. Und damit meine ich jetzt nicht aktuell die Ausstattung mit Videotechnik, sondern wirklich den gezielten Einsatz von Algorithmen, die einfach die justizielle Arbeit unterstützen. Erforderlich ist aber nicht, dass die Justiz eine Monopolstellung einnimmt, sondern es ist eigentlich viel erfreulicher, wenn ein ausgeglichenes Nebeneinander von Justiz und den alternativen Schlichtungsstellen bestehen würde. Der zweite Punkt ist, dass die Justiz bei der Kreierung von neuen Verfahren, und hiermit meine ich jetzt gerade zum Beispiel solche Verfahren für Verbraucherstreitigkeiten, also solche mit niedrigen Forderungswerten, sich bei der neuen Kreierung gerade vom Rechtssuchenden aus denken sollte. Also bezogen auf Verbraucherverfahren bedeutet das dann zum Beispiel, welche Tools braucht eigentlich der durchschnittliche und rechtsunkundige Verbraucher, um seinen Anspruch durchzusetzen?
Super, vielen Dank. Ja, last but not least, das Panel, das wir gerade gehört haben. Julian, möchtest du auch noch ein paar Impulse geben?
Gerne, ja. Ich kann perfekt an Janniks letzten Satz anknüpfen, weil mit dem CRT in Kanada genau das schon geschaffen wurde, dass man einfach einen Online-Zugang hat und sich alles um den Nutzer dreht und dieses nutzerzentrierte Denken in den Mittelpunkt gestellt wird von einem gerichtlichen Verfahren. Und wie wir gelernt haben, muss das nicht zwingend online sein, aber online ist bisher unsere beste Alternative, die wir kennen. Und wenn wir das zum Anlass nehmen, wirklich über den ganzen Prozess nachzudenken und nicht einfach nur analoge Prozesse in Digitales zu übersetzen, dann ist das eine Riesenchance. Und das fand ich super inspirierend, weil wir das auch die ganze Konferenz hindurch immer wieder gehört haben, nicht analog einfach in digital übersetzen, sondern nochmal neu denken. Sandboxing wurde genannt, regulatorische Sandkasten, einfach mal ausprobieren, mal machen. Und da zeigt uns Kanada, dass es einfach auch schon jetzt geht. Und da waren wir sogar noch viel bescheidener. Auf dieser Conference waren sich gestern im Panel eigentlich alle einig, okay, wir brauchen eine zweigleisige Strategie. Kurzfristig können wir verschiedene kleine Anpassungen machen und in 10 Jahren denken wir dann über den großen neuen Wurf nach. Und das hat Kanada eigentlich schon jetzt. Also vielleicht nochmal der Impuls von dieser Konferenz, kann man sogar noch ein bisschen ambitionierter sein. Klar, kleine Anpassungen in der Masse, erstmal Laptops kaufen für alle, aber vielleicht auch schon in 5 Jahren dann einen Civil oder wie man es dann in Deutschland nennt, also ein Online-Gericht für kleine Streitwerte und eine begrenzten Jurisdiktion.
Ja, und um da vielleicht auch nochmal anzuknüpfen, was, glaube ich, auch eine der Erkenntnisse dieser Konferenz jetzt war, ist, dass man diesen Austausch und auch Initiativen mit den Vertretern eben aus allen Professionen, also der Anwaltschaft, der Justiz, der Wissenschaft und eben auch der IT forcieren muss. Und wir hoffen sehr, dass wir diesen Austausch ja in den letzten beiden Konferenztagen ermöglichen konnten und würden uns auch darüber hinaus freuen, wenn wir diesen Austausch weiter forcieren können und möchten dahingehend mit Ihnen und mit euch in Kontakt bleiben und würden uns daher sehr freuen, wenn wir uns über Social Media vernetzen und Sie unsere Newsletter abonnieren, als auch den Podcast, damit Sie da einfach auf dem Laufenden bleiben, was bei uns als nächstes ansteht, denn es steht einiges an und darüber würden wir uns sehr freuen. Und zu guter Letzt möchte ich dann noch ein paar Danke oder Danksagungen rausgeben. Zum einen nochmal ganz herzlich an unsere Sponsoren, NER, Baker McKenzie, Bird & Bird und Wolters Kluwer für die ganze Unterstützung jetzt während der Konferenz als auch darüber hinaus eben im Rahmen unserer Vereinsarbeit. Und ja, auch last but not least wäre diese Konferenz nicht zustande gekommen, wäre nicht das Team, was ihr jetzt auf dem Bildschirm seht, wenn das nicht vorhanden gewesen wäre. Und da möchte ich mich einfach nochmal ganz, ganz herzlich bedanken für diese unermüdliche Arbeit in den letzten 5 Monaten. Es ist total verrückt, dass diese Zeit nun um ist und ich bin gespannt, was wir morgen dann alle machen werden, wenn die Konferenz nun zu Ende ist. Aber zunächst einmal ein riesen Dankeschön an das Marketing-Team, insbesondere da an Henrik, Hanna und Johannes für das ganze Jahr Online-Marketing, die Sharepics und die Ads und die letztendlich maßgeblich da zu dem großen Zuspruch der Conference beigetragen haben, denn wir können letztendlich über 460 Teilnehmer und Anmeldungen verzeichnen und das wäre in Persona, glaube ich, sehr schwer umsetzbar gewesen. Deshalb ein großes Dankeschön da an euch. Zudem natürlich auch ein Riesendankeschön an die inhaltliche Konzeption und vor allem auch die Durchführung der Panels. Da geht ein Riesendankeschön an Pauline, an Yannick und auch an Julian raus. Ohne euch, wäre dieses Programm, glaube ich, nicht so zustande gekommen, wie es jetzt letztendlich über die Bühne gebracht wurde. Konzept und Programm hin oder her, ohne Technik geht natürlich so oder so nichts. Also da, Konsti und Kai, herzlichen Dank an euch, vor allem für das Arbeiten im Background, was man nie so mitbekommt, aber da fällt doch echt immer einiges an. Ja. Und auch sonst ein riesen Dankeschön an alle Mitglieder von Recode Law, die sich engagiert haben.
Das hast du bei der Technik aber David vergessen, Ramona.
Das kommt jetzt, das Beste kommt zum Schluss. Ich möchte ganz gerne David einmal gesondert danken, da er sowohl bei der Technik als auch im Marketing, als auch bei der Speakerbetreuung, also praktisch bei der ganzen Konferenz überall dabei war. Und David, ohne dich wäre das so nicht zustande gekommen, wie es jetzt, wie gesagt, zustande gekommen ist. Deshalb da wirklich ein riesen Dankeschön an dich.
Ja.
Genau.
Danke zurück. Das hat sehr viel Spaß gemacht.
Ja, danke an dich, Ramona,
Eben.
als Leiterin, die alles zusammengehalten hat und uns immer wieder erinnert hat. Ohne dich wäre es auch nicht möglich gewesen.
Wir müssen mal schauen, was wir jetzt freitags, nachmittags machen. Ab 17 Uhr. Ja. Die letzten 5 Monate, was wir jeden Freitag gemacht haben.
Das stimmt. Super. Ja, es hat sehr viel Spaß gemacht und natürlich auch sehr viel Spaß gemacht mit euch und mit Ihnen als Publikum. Denn da sind ja echt einige sehr spannende Diskussionen entfacht und dafür danken wir auch ganz, ganz herzlich. Und zu guter Letzt wirklich auch, bevor Sie in den Feierabend entlassen werden, ein herzliches Dankeschön an die Speaker, die uns einfach so viel Zuspruch zukommen haben lassen. Ohne Speaker geht das Ganze natürlich auch nicht. Und da einfach als Non-Profit Recode Law so viel Zuspruch zu bekommen und so viel Unterstützung, das bedeutet uns wirklich sehr, sehr viel. Und wie gesagt, an jeden einzelnen Speaker, der an dieser Conference teilgenommen hat, herzliches Dankeschön. Und wir würden uns, wie gesagt, sehr freuen, mit euch und mit Ihnen in Kontakt zu bleiben und freuen uns auf die nächste Konferenz dann in 2021. Also stay tuned und wir freuen uns drauf. Und jetzt zunächst einen schönen Feierabend. Genießen Sie Ihr Wochenende und dann bis ganz bald. Vielen Dank.
Danke. Ciao.
Danke.
Ciao.